Durable financial power of attorney, how it works, and do I need one? A durable power of attorney for finances, or financial power of attorney, is a cheap, easy, and reliable way to plan for someone to take care of your finances if you become incapacitated or unable to make decisions for yourself. It is a great document to make for yourself, but it also can prove extremely useful for your loved ones. Keep in mind that courts will inevitably get involved if, God forbids, you can no longer decide for yourself and you haven't prepared a durable power of attorney. In that case, your spouse, companion, or closest relatives will have to ask a court for authority over at least some of your financial affairs. Watch now to learn more. Welcome back, folks, to another edition of Sweetie Kiwi. How you doing today? Hope you are doing fantastic. If you are doing as terrific as I am doing, go grab a cup of coffee or tea or vodka and let's roll. Today I want to talk to you about durable financial power of attorney, how it works, and do I need one, or do you need one? When does a financial power of attorney take effect? A financial power of attorney can be drafted so that it goes into effect as soon as you sign it. Many spouses have active financial powers of attorney for each other in case something happens to one of them, or for when one spouse is out of town. So you want to clarify, you want to specify that you want your power of attorney to be durable. If you don't, in most states, it will automatically end if you later become incapacitated. So the word durable is critical. Or you can specify that the power of attorney does not go into effect unless a doctor certifies that you have become incapacitated. The idea here is that the financial power of attorney kicks in when you become incapacitated. So you need to either lay out the criteria that experts or the courts must look into before declaring you incapacitated, or you can transfer that authority, that legal authority, to a doctor so that the doctor can certify that you are indeed have become incapacitated. And this is, by doing that, this is called a springing durable power of attorney. It allows you to keep control over your affairs unless and until you become incapacitated. In other words, when it springs into effect, when the incapacitation has been proclaimed by a doctor or another expert, then the powers, the legal powers inherent to the durable power of attorney spring into effect. However, springing powers of attorney can cause serious delays and problems for your agent. We have covered this topic in another show, so you might want to double check that and see. We have a show around springing power of attorney, so I strongly recommend that you check that show out. Now, speaking about problems for your agent, let's look at your agent's job. So when you assign a durable power of attorney, you are in essence giving another person legal authority to act on your behalf. Now, this person can be called your agent. In some states, he or she is called your attorney, in fact. Generally, people give their agent broad power to handle all of their finances. But you can restrict that power. It is up to you. The ball is in your court. You decide what you want to give and you decide what you want to restrict. You can give your agent as much or as little power as you wish. You may want to give your agent authority to do some of the following, some or all of the following. Depends on you. Use your asset to pay your everyday expenses and those of your family. Buy, sell, maintain, pay taxes on, and mortgage real estate and other property. Collect Social Security, Medicare, or other government benefits. Invest your money in stocks, bonds, and mutual funds. Handle transactions with banks and other financial institutions. Buy and sell insurance policies and annuities for you. File and pay your taxes. Operate your small business. Claim property you inherit or are otherwise entitled to. Transfer property to a trust you've already created. hire someone to represent you in court, and manage your retirement accounts. As you can see here, we have a large collection of tasks and duties that are assigned to your agent, your attorney, in fact. So the agent, in this case, is legally required to act in your best interest, and he or she must maintain accurate records and keep your property separate from his or hers. And most important, avoid conflicts of interest. Courts in the last few years have been very adamant in making sure that agents, aka attorneys, in fact, are maintaining a strong set of controls and safeguards that enable them to avoid conflicts of interest. Because as you can see, the long list of authorities that are given to an agent is this is humongous. That list is expensive. It is broad. So if you give an agent so much power, there has to be checks and balances. And the courts have been very good at making sure that the interest of individuals, the interest of trust makers, the individuals of the person who is incapacitated, the interests of that person are being taken into account when they can no longer speak for themselves. I'll be right back right after this. Don't go anywhere. Welcome back, folks, to another edition of Sweetie Kiwi. We are talking today about durable financial power of attorney, how it works, and whether or not you need one. Let's talk about making a financial power of attorney. To create a legally valid, durable power of attorney, you don't need a lot, really. All you need is to properly complete and sign a fill in the blanks form that is a few pages long, depending upon the states. Some states have their own forms, but it's not mandatory that you use them. If you go on the internet, there are gazillions of templates out there about financial power of attorney. Some banks and brokerage companies even have their own durable power of attorney forms. So if you want your agent to have an easier time with these institutions, it might be better to prepare 2 or more durable powers of attorney. So you have your own form on one end, and on the other, forms that were provided by the institutions with which you do business. That way you don't have any inconsistencies, you don't waste time. Your agent does not waste time when dealing with those institutions. Remember to sign the document in front of a notary public. In other words, you want to notarize the documents. In some states, witnesses must also watch your sign. So if your agent will have authority to deal with your real estate, you must put a copy of the document on file at the local land records office. Quick info though, in 2 states, North and South Carolina, you must record your power of attorney at the land records office for it to be durable. Let me repeat that. In 2 states, North Carolina and South Carolina, you must record your power of attorney at the land records office for it to be durable. It is important also to understand that you can notarize, nowadays you can notarize documents as important as financial powers of attorney, wills, trusts, and other estate planning documents. You can do that. You can notarize them online. So the federal government has been making it very easy for citizens to do the notarization online, especially in the current situation of the COVID-19, where we have a pandemic and the social distance rules. You can notarize. You can even have witnesses, people witnessing your signature of the form online. Now, let's talk about when a financial power of attorney ends. Your durable power of attorney automatically ends at your death. So once you pass away, everything ends. That means that you cannot give your agent authority to handle things after your death. I'm talking here transferring your property to the people who inherit it, paying your debt, making funeral or burial arrangement. Your agent cannot do those. If you want your agent to have authority to wind up your affairs after your death, use a will to name that person as your executor. So the persons will have to be both your executor and your agent. Your durable power of attorney also ends if you revoke it. So as long as you are mentally competent, you can revoke a durable power of attorney at any time. States are very flexible with that. You can also end it if you get a divorce. In a handful of states, if your spouse is your agent and you divorce, your ex-spouse's authority is automatically terminated, right? Because the relationship, the legal relationship in this case, the legal relationship of attorneys in fact was based on the marriage. So if the marriage has crumbled, if the marriage no longer exists, the legal foundation has vanished. So the corollary authority, the corollary power of attorney also extinguishes. In other states, if you want to end your ex-spouse's authority, you have to revoke your existing power of attorney yourself. In any case, it is always wise to make a new document as soon as you file for divorce. Your durable power of attorney also ends if a court invalidates your document. This is kind of rare though, but a court can certainly declare your document invalid if it concludes that you were not mentally competent when you signed it, or that you were the victim of fraud or undue influence, or were under duress, under stress, under pressure. Your durable power of attorney also ends if no agent is available. So to avoid this problem, you can name an alternate agent in your document. So you have agent A and you have a backup agent. So if the primary agent is not available, the legal authority will switch automatically to your secondary agent. I'll be right back right after this. Don't go anywhere. Welcome back, folks, to another edition of Sweetie Kiwi. We are having a conversation today around durable financial powers of attorney, how they work, and do you need one or two or three? Financial powers of attorney, do you really need one? Let's talk about it now. Almost everyone can benefit from a durable power of attorney for finances. Creating a durable power of attorney for finances, and this is sometimes called financial power of attorney, is always a great idea. And this applies to almost everyone who has property or an income. It's particularly important, however, if you fear that the health problems may make it impossible for you to handle your financial matters. Only you know the conditions you currently have. So it is a way to mitigate the risk. It is a way for you, if you know that you are at risk of some crippling disease or something might happen, it is particularly important to have one. Why should you sign a power of attorney? Making a durable power of attorney ensures that someone you trust, again, you can call the person, agent, or attorney in fact, will be on hand to manage the many practical financial tasks that will arise if you become incapacitated. For example, remember, simply because you have become incapacitated doesn't mean the bills don't have to be paid. They still must be paid. Bank deposits must be made. Someone must handle insurance and benefits paperwork, and a whole host of other financial tasks. Many other matters may need attention as well. Again, from handling property repairs to managing investments or a small business. In most states, a durable power of attorney for finances is the best way to take care of tasks like this. Let's talk now about avoiding conservatorship or guardianship proceedings. If you don't have a durable power of attorney and, God forbid, something happened and you become incapacitated, your relatives or other loved ones will have to ask a judge to name someone to manage your financial affairs. Depending on where you live, the person appointed to manage your finances may be called a conservator, a guardian of the estate, a committee, or a curator. So those four terms are interchangeable. A conservator, a guardian of the estate, a committee, or a curator. Whenever you hear those terms in the context of estate planning, they mean the same thing. Conservatorship or guardianship proceedings can be very expensive and embarrassing. So your loved ones must ask the court to rule that you cannot take care of your own affairs. And this is a public airing of a very private matter. Think about it. Court proceedings are matters of public records. In some places, a notice may even be published in a local newspaper. So if relatives fight over who is to be the conservator or guardian, for instance, the proceedings will surely become even more disagreeable, sometimes downright nasty. We all know how fights over estates, fights over assets can be nasty. And all of this causes costs to mount up, especially if lawyers must be hired. I'm not even talking about court fees here. So if we want to switch the conversation from conservatorship or guardianship proceedings and avoid all the nasty fights, let's think about what to do if, for instance, you think you don't need a durable power of attorney. You may not think that you need a durable power of attorney for finances if you are married, or if you've put most of your property into a living trust, or you hold it in something called joint tenancy. But the truth of the matter here is that in all of these situations, a durable power of attorney can make life much easier for your family if you become incapacitated. Let's say if you're married. If you're married, your spouse does have some authority over property you own together, for example, to pay bills from a joint bank account or sell stock in a joint brokerage account. Again, the key word here is joint. As long as it's joint, he or she can transfer property as he or she wishes. There are significant limits, however, on your spouse's rights to sell property owned by both of you. For example, in the majority of states, both spouses must agree to the sale of co-owned real estates or cars. Because an incapacitated spouse cannot consent to such a sale, the other spouse's hands are tied. Think about it. When it comes to property that belongs only to you, your spouse has no legal authority without a durable power of attorney. Another example here is that institutions may also refuse to deal with one spouse without a valid power of attorney. If a bank, for instance, doesn't want to deal with the other spouse, then there is a problem. Let me give you an example. Adam's wife, Mary, suffers from dementia, and as her condition worsens, Adam realizes that she needs nursing home care. And as a good husband, he calls the insurance company that issued Mary's long-term care policy, but the insurance company will not talk to him because he's not the policyholder and does not have a valid power of attorney. Think about that. Here is a husband who wants to take care of his wife, and the insurance company, the financial institutions, is not cooperating. Now, it's not the insurance company's fault. It is Mary and Adam's fault because they haven't set up a durable power of attorney. In this situation, the spouse may end up having to go to court to request a conservatorship or a guardianship to get control over the incapacitated spouse's asset. And all of this adds financial and emotional burdens to an already stressful time. Now, what do you do if you have a living trust? A lot of people think that a living trust is a substitute for a durable power of attorney for finances. No, a living trust is not a complete substitute for a durable power of attorney for finances. It can be helpful though if you become incapable of taking care of your financial affairs. That's because the person who will distribute trust property after your death, this person is called the successor trustee, also in most cases has authority to take over management of the trust property if you become incapacitated. However, the successor trustee has no authority over property not held in the trust. So few people will transfer all of their property to a living trust. Most people will transfer only assets that are expensive to probate, such as real estate and valuable securities. A durable power of attorney ensures that someone will be on hand to take care of other property as well as day-to-day financial task. Now, what if you own joint tenancy property? Let's kind of break it down here. What is joint tenancy? Joint tenancy is a way that more than one person can own property together. So when one owner dies, the other owners automatically inherit the deceased person's share of the property. But if you become incapacitated, not dead, but if you become incapacitated, the other joint tenant owners have very limited authority over your share of the joint tenancy property. For instance, if you and someone else own a bank account in joint tenancy and one of you becomes incapacitated, the other owners is legally entitled to use the funds. The healthy joint tenant in this case can take care of the financial needs of the incapacitated person simply by paying bills from the joint account. But the other account owner has no legal rights to endorse checks made out to the incapacitated person. In practice, it might be possible though to get an incapacitated person's checks into a joint account by stamping them for deposit only, but that's not the easiest way to handle things. Matters can even get worse or complicated with other kinds of joint tenancy property. Let me give you an example. Real estate. If one owner becomes incapacitated, the other has no legal authority to sell or refinance the incapacitated owner's share. By contrast, if you have a durable power of attorney for finances, you can give your agent authority over your share of joint tenancy property, including real estate and bank accounts. I'll be right back right after this. Don't go anywhere. Welcome back, folks, to another edition of Sweetie Kiwi. We are also having a conversation today around durable powers of attorney and how they work and whether you need one. Let's now talk about when you should not rely on a durable power of attorney. I've given you a lot of pros about the durable power of attorney. Let's talk about the cons a little bit. The expense and intrusion of a conservatorship or a guardianship are rarely desirable. In a few situations, however, special concerns justify the process. In other words, it makes sense from a legal and judicial perspective to allow a conservator or a guardian to sort of meddle into your personal affairs. Let's say you want court supervision of your finances. If this is what you want, if you cannot think of someone you trust enough to appoint as your agent with broad authority over your property and finances, do not create a durable power of attorney. You can transfer that authority, that right, to the courts. A conservatorship or a guardianship with the built-in safeguards of court supervision may be worth the extra cost and trouble. Let's say also that you fear family fights. If you fear family fights, you should not rely on a durable power of attorney, because a durable power of attorney is a readily accepted and powerful legal document. Once we have finalized yours, anyone who wants to challenge your plans for financial management will face an uphill battle in court. And courts have been consistent about this for the last 50 years. But if you expect, for instance, that family members will challenge your documents or make continual trouble for your agent, a conservatorship or a guardianship may be preferable. So your relatives may still fight, but at least the court will be there to keep an eye on your welfare and your property. In other words, the court will introduce an independent person, a non-relative person, into the whole equation. As a conservator or a guardian, that person will be able to take care of you without meddling too much or without worrying too much about family infighting, because the court will have authority over that. And if your family members go overboard, the court might make decisions that are outright adverse to them. All right, folks, this was it for today. Just want to quickly recap today's conversation. We were talking about durable financial power of attorney, how it works, and do you need one? And I want to quickly recap here. I spoke to you about when a financial power of attorney takes effect, your agent's job, making a financial power of attorney, when a financial power of attorney ends, financial powers of attorney, whether you need one, why sign a power of attorney, avoiding conservatorship or guardianship proceedings. If you think you don't need a durable power of attorney, if you are married, if you have a living trust, if you own joint tenancy property. And I also spoke to you about when you should not rely on a durable power of attorney. For instance, if you want court supervision of your finances or you fear family fights. I will talk to you another time. But until then, remember, stay marvelous.